So welcome. We'll be joined, no doubt, by others. There are still classes and other things that are keeping some of our MA students here from coming now. But I'm glad to see a number of PhD students and faculty for this evening's very interesting discussion. And those who aren't here are going to regret it, because this will be quite a stimulating time. I think you all know that we've been having a series of programs devoted, what we call dialogues on democracy, but also, and I see Doro Bole here, a very effective program on Spotlight on Hungary, and the two are in a sense related. The program on Dialogue on Democracy is really looking at the broad perspective on what's happening with democracy today. What are some of the great issues that are challenging and even the very meaning of democracy? And certainly the way in which it's implemented and the nature of constitutional democracy. And you don't have to go any further than where we're sitting right today here in Budapest to see that there certainly is a very deep set of disagreements about the nature of constitutional democracy, certainly here in Hungary, but elsewhere in Europe and far beyond as well. So our debate series, and it is a kind of debate series, we're trying to bring together people who aren't necessarily going to agree on all the issues, began last year looking at the fragility of some of those democracies that are seen to be fully settled, Western democracies, the United States, Western Europe, parts of Western Europe, elsewhere, and how fragile some of the institutions of democracy are and how ineffective some of those institutions have become. We also looked at the role of the social media and networks in a much more implementing context. I mean, how do social media and networks impact on non-democracies, and particularly in bringing down authoritarian regimes? And of course, there are examples, particularly in the Arab world, and other examples beyond that. But then it's also a double-edged sword, as we discussed, and some of the new means of communication can be very effectively used by authoritarian regimes, particularly in China and elsewhere, or blocked in some ways so that they aren't as much of an instrument of the promotion of democracy. Then we also looked at the dangers that the demand for security, which is very active as a demand, and being used in this period of heightened awareness of terrorism, et cetera, how that is impacting very severely on democracy, and in some cases how authoritarian regimes are using the willingness of democratic regimes or democratic countries to heighten security as a way of further curtailing democratic development. So tonight, we're going to explore a topic that's really, in many ways, I would say, and I don't know whether our speakers will agree, at the heart of the crisis over the future of the European Union. And that is, what is the tension and how does it play out between national and supranational constitutions? What happens when supranational institutions are increasingly moving in areas that have been previously occupied and continue to be occupied by national constitutional arrangements? Certainly, if we look at the EU and the IMF and the World Bank and the EBRD and the International Criminal Court, there are many ways in which these supranational institutions, in order to advance the benefits that they bring, also involve some curtailment of sovereignty, or at least interact with sovereignty in ways that lead to reaction in some countries. So the big question, which is asked of tonight in our distinguished panel, is, and there's no clear answer, obviously, do supranational institutions reinforce constitutional democracy, or are they an imposition which can erode them, and how can the two be brought together? So this is certainly not an academic question. It is a very real and lively and immediate political question, and to address either this question or any other question that they may wish to raise, we have an extremely distinguished group of three speakers on our panel who I will briefly introduce and then turn to my colleague Renate Uitz to moderate and chair the discussion. Dieter Grimm is a professor of law at Humboldt University and at the Yale Law School. From 1987 to 1999, he served as a judge on the Federal Constitutional Court of Germany. And during this period, he was also the judge rapporteur for freedom of speech and freedom of the media and various other issues of freedom, associational freedoms. He was, from 2001 to 2007, he was the director of the Wissenschaftskolleg zu Berlin, where he's still a permanent fellow. Our second panelist, Mattias Kumm, is professor of law of New York University, as well as a professor of globalization and the rule of law at the Social Science Research Center at Humboldt University. His research and teaching focuses on basic issues in global, European, and comparative public law. He was a visiting professor at Harvard University on world organization, and he has been a visiting professor at Bucerius Law School and has taught and lectured at many other universities. Our third panelist, Miroslaw Wyrzykowski, is a professor of law at Warsaw University, and until 2010, he served as a judge on the Polish Constitutional Court. So we have all sorts of constitutional issues that can be discussed amongst our panel, certainly those that they've dealt with in the past. Between 1988 and 1990, he was head of the Department of Constitutional Freedoms and Rights in the Office of the Commissioner for Citizen Rights in Warsaw. So I ask you to join our distinguished moderator and myself in welcoming this extraordinary panel of leaders in the field of comparative constitutional law to CEU. Thank you.
Thank you very much, John. And it's a real honor to chair a panel with two former Constitutional Court justices and a law professor who looks at Europe from the US and then lives in Europe half time. So that's a very good combination to discuss these issues. The format we planned for tonight is that each panelist will make an opening statement for about 10-12 minutes. Then the panelists, if they feel the urge, will respond to each other. And after that, we will open the floor for questions and answers. So we are very much hoping that the three contributions will trigger debate and curiosity on your part, and you will join us in the discussion. I first would like to ask Professor Judge Grimm to make his introduction.
Well, I think I will start my attempt to answer the question whether supranational laws erode domestic democratic systems by making a preliminary statement. The preliminary statement is international laws, supranational laws certainly affect national democratic systems. Whether or under which circumstances they erode national democratic system, I keep that for a little bit later. But first, why do they affect national democracies? If the meaning of democracy or a democratic system is that political power, in particularly lawmaking power, should only be in the hands of persons who have a mandate from the people and exercise this power only accordingly to rules that are prescribed by their people, normally in the constitutions. And if for this use of power they are accountable to the people, then every transfer of public power, especially of lawmaking power, to supranational institutions affects the national democracy. It means that persons participate in decisions that have a direct impact on the territory of the national democracy who have no mandate from that people. And it means that they do it according to rules other than the rules in the national constitution. And as organs of a supranational institution, they are not accountable to the people of the national members of that institution. The fact that the decision to transfer public power to supranational organizations has been taken by democratically legitimized agents on the national level and has been done according to the rules of the domestic constitution does not mean that every use of the transferred power by the agents of the supranational institution is at the same time the direct will of the nation state, as some scholars of European law say. Since the power was transferred democratically, everything that comes back, that returns to the nation state, is at the same time an expression of the will of the domestic people. This I don't believe. To the contrary, the supranational decision can run counter an explicitly articulate national will. The degree to which national democracies may be affected is mitigated if the member states have a veto against decisions of the supranational organs. Yet, if the state can only participate, if it just has the right to participate in supranational decision-making, but the majority rule counts, and even more so, if the decisions of on the supranational level are not taken by institutions, organs in which the nation states are represented, then the democracy is affected. Legal acts that are binding on the territory of the state are not comprehensively subjected to the requirements of the national democracy, but only partially, only insofar as they are state actions. What I would like to add is that this is not necessarily a violation of the democratic requirement of the national constitutions. Constitutions may permit the transfer of power to the supranational level, or constitutions may give priority to international law, as for instance the Netherlands constitution does. However, this does not change the result that national democracies are affected. That was my first point. My second point, being affected does not necessarily mean being under erosion, being in a situation of erosion. I think it would even be a mistake to regard the limiting effects that supranational lawmaking may have on national democracies. It would even be a mistake to regard it only in terms of loss or in terms of decay. If national constitutions provide for a transfer of powers, and if states decide to establish supranational organizations, and if they endow them with public power, this is usually not a sacrifice. Rather, they expect something in return. In particular, they expect something in return which they themselves cannot produce. So more security, for instance, more prosperity, an enhanced problem-solving capacity. And they expect that the gain outweighs the loss. And of course, it is a mutual enterprise. It's not a unilateral enterprise. States, by establishing supranational organizations, grant other states influence on their own matters, but in return they gain influence on the matters of the other societies and the other states. Furthermore, the democratic loss on the domestic level is less severe if there is a democratic compensation for this loss on the international level. In most cases of supranational institutions, this compensation, democratic compensation on the international level is rather weak, but this is not true for the European Union. The European Union no longer exclusively depends on the democracy that comes from the member states. The European Union has a democratic legitimacy of its own, and it's mediated, this own democratic legitimacy is mediated by the directly elected European Parliament. Yet it is a weaker legitimation than the legitimation in national democracies. First of all, European elections, as everybody knows, remain more or less a national matter. That's to say, the election operates under the national election laws. It is the national political parties that compete. The national political issues play a role in the election campaign, not European issues, and the results of the election are more or less in every country evaluated with regard to what does that mean to the political system of my own country. Secondly, the powers of the European Parliament do not extend to the powers that parliaments used to have on the national level. And thirdly, and perhaps most importantly, the societal preconditions of democracy are very weak on the European level compared to the national level. I mean, especially the existence of a European-wide public discourse, the existence of European-wide societal institutions. I think I don't have to speak longer about that. This is the reason why the German Constitutional Court insists on an adequate relationship between the extent of transferred powers and the standard of democracy on the supranational, on the European level. That's to say, the Constitution is a barrier to the transfer, to the further transfer of powers to the European level, if this adequacy between extent of powers and degree of democracy is not reached. Now, my third and last point is the fact that the national democracy is affected by the transfer of legislative powers. Is this at the same time an erosion of the national democracy? I think the answer would have to be given for every supranational institution separately. It's very difficult to compare them. This would by far exceed my 12 minutes, so I'd say a few words only on the European Union. The German Constitutional Court, again, sees two dangers of erosion. The first is a quantitative danger. There would be an erosion if so many legislative powers were transferred to the European Union that there would be no longer sufficient issues, sufficient subject matters for decision of the German parliament, and this would at the same time turn the right to vote of every German citizen into an empty shell. This is the quantitative concern that the German court has. And there's also a qualitative concern. If powers are transferred that are of a special importance to the national democracy. In particular, if the power to determine the powers of the European Union were transferred. This is what everybody knows by the nice German word which entered into international language, competence. If the competence were transferred, then this would be an erosion, not only an effect to national democracy. With other words, if the treaty amending power, or in other words, the constituent power of the European Union would be handed over to the European Union itself, would be given up by the member states. And the power to determine the integration program of the European Union. The German court sees two possible ways for this to happen. One way would be the explicit way, by concluding a treaty that, for instance, would hand over the competence. But there is also a second way, a creeping way, so to say, namely by interpreting the existing treaty in a way that amounts to a new treaty or to an amendment of the treaty. Certainly, in my view, the second way is the bigger danger to national democracy. And this danger, this way, is facilitated by a peculiarity of European Union law, which, in my view, is often overlooked. As everybody knows, the legal foundation of the European Union are international treaties, but these treaties have been constitutionalized by the European Court of Justice. The court interprets the treaties not in the way international law is interpreted, but it interprets the treaties in a way constitutions are interpreted. And it declares the treaties as higher law, that's to say they trump, in the view of the European Court of Justice, national law, including the highest national law, the national constitutions. But unlike constitutions, the European treaties are full of provisions that on the national level would be ordinary law. The whole European competition law is not on the level of ordinary law, it is in the treaty and thereby, so to say, constitutional law. And this has a number of consequences. What is in the treaties can be directly enforced by the administrative and the judicial organs of the European Union. It's no longer in need of being concretized and put into effect by legislature, as this is the case in domestic constitutions. Domestic constitutions usually establish organs, prescribe the procedure of these organs, give some guidelines for how these powers should be taken, but the rest is left to a political decision that depends on who won the majority in the last election. All this is absent if everything that we would call ordinary law on the national level is in Europe on the constitutional level. One effect is the effect that was early observed and described by a German political scientist, Fritz Scharpf, the discrepancy between negative and positive integration, probably known to the majority of you. Negative integration meaning national barriers to free trade are declared incompatible with European law, that's to say they disappear. Positive integration would mean they are replaced by European laws, but declaring national laws incompatible with European law is easy because that can be done by the Commission, and the Commission will usually get the approval of the court. Legislating, harmonizing, creating European laws that fill the gaps is much more difficult because of the high threshold for European legislation. Effect number two, for everything that is in the treaties, the democratically legitimated and controlled institutions of the European Union are left out of the game. That's to say, the European Parliament has no say in this effect. The Council, where the democratically elected and controlled member states' governments are represented, is out of the game. If the political instances on the national level are dissatisfied with what the judiciary makes out of their laws, it can correct the judiciary, by amending the law. If the law is in the treaty, domestic situation, if it is in the constitution, it is much more difficult. You need a supermajority, and on the European level, it's almost impossible. You need a treaty agreed to by all 27 instances. So, the possibility to politically correct the decisions that are taken on administrative and adjudicative paths exist. On the national level, they are almost inexistent with regard to everything that is regulated in the treaties on the European level. And effect number 3, in spite of the dissatisfaction that national governments may have with the way the European instances interpret and enforce the law, in spite of their dissatisfaction, they have virtually no means to react, and that means at the same time that the gap between those who have the decision-making power and those who are made accountable for the decisions widens. The European institutions that make these decisions are not affected by the outcome of European elections. They are more or less democratically unaccountable. So what do people do? They make accountable those institutions who enforce and who implement, and these are the national governments, but they are blamed for things that they are not responsible for. I think this is, I think, in my view, the real democratic problem, and not the design of the institutional arrangement in Europe, which is mostly made responsible for the democratic gap. So here I see dangers of erosion of national democracies without a sufficient compensation on the European level. I hesitate to say that national democracies have eroded, but again, I would say here is a source. Here is a source of erosion, a source of danger that we should be aware of.
Well, thank you very much. And now let me turn to Professor and Judge Wyrzykowski, who oversaw transition to democracy in educational and advisory capacities, and then landed on a constitutional tribunal to see EU accession and then the European arrest warrant. So let's see what he has to add to this.
Thank you very much. I'm extremely honored and happy to be here tonight due to different reasons. First of all, I'm feeling at home at the CEU. Thank you very much for the invitation. I have some comments on this issue. Firstly, I try to understand what does it mean, erode. And I found it indeed two meanings of this notion. Once, already discussed, erosion, let's say negative. But another one is erode, to create, to carve, to make more beautiful, more tuned. Means it is excellent way, excellent part to upgrade certain level of wood, of legal system, of a set of rules of democracy, and so on and so on. So I try to ask the question asked by organizers, how international supranational law may erode in these two meanings. But firstly, what does it mean constitution? We know, all of us. What does it mean constitutionalism as element of discussion and subject is not so sure. Each element of the Constitution might be subject of interpretation, but even more, every element of the notion constitutionalism might be, and is a subject of interpretation. Separation of powers, France, Poland, Hungary, United States. Independence of judiciary, I will touch upon later on. Menschenwürde means dignity of human being, a fundamental issue, is a subject of discussion in because of different reasons. So, if it is the case, I try to list some implications of supranational law on the constitutions. And as we may see, there are different possibilities of impact, as Professor Grimm said, on the constitution. If we see South African constitution, we may see that indeed this constitution was induced by public international law. If we take another example, like Afghanistan or Sri Lanka, it was accompanying process by use of public international law. If we take example Cambodia or East Timor, we may see that this process was directed by supranational public international law. And last but not least, Kosovo case, it was imposed by international law. Is it erosion? The effect was to erode in the sense of erosion, or to erode just to come to the better outcome as it would be without use of supranational law. Another problem is that indeed, as Mr. President stressed, there are different international organizations, and it is a set of rules and norms and systems, legal systems. And if we take as an example United Nations and Security Council and the resolutions of the Security Council, then we may see an impact of this decision and this concept of legal system on the level of self-legitimacy, of self-perception of legitimacy to decide on the impact of the decision, resolution of the European Security Council on the European law. Cadi case is a perfect example. First instance, decision of the Court of First Instance, very open, German would say, UNO-friendly decision of the First Instance Court. Second decision, extremely sovereign in the sense of the temptation to keep a sovereign position of the European Union towards international law. WTO, TRIPS 1, TRIPS 2, an impact of patent law on the domestic constitution from the perspective of the healthcare and the obligation of the state to provide help and the medicine and any type of sources for protection of health. And then European Union, of course. Erode means erosion, or erode means curve and do things better. It depends. There is no one-dimensional answer. My favorite case is the Charter of the Fundamental Rights of the European Union and the British-Polish Protocol. The British-Polish Protocol indeed is type of reservation concerning Chapter 2 of the Charter. Chapter 4 means solidarity. There are social rights, but not Poland, because Poland adopted in 1997 all social and economic rights by its constitution. No difference between the Charter and the Constitution. Indeed, this reservation was based on 3 fears expressed by politicians, that full application of the Charter may impose negatively on the, as we would say now, a constitutional identity of Poland. Why? Because it was the fear concerning abortion, euthanasia, and same-sex partnership. Politicians expressed their fear that Court of Justice, by its judgment, may impose on Poland legislation which should contradict to the history and especially to the Christian morality of the society. So there is a tension concerning impact of supranational law on the legislation, and in this last case, from the Polish perspective, it depends who is judging this situation. For those who are conservative, close to the Catholic Church, this Polish-British protocol is a miracle, using the wording of different faith. It's a miracle as protection of the sovereignty. For another people, not extremely close to the church, they would say, let's give us the chance to curve the Polish legal system, to open the Polish legal system to the standards which are not necessarily and exclusively linked to the traditional values of the Polish society, because the Polish society, they are not only Christians. So supranational impact might be of different perspective and different values. And very last, I have only 2 minutes left. Thank you for generosity. I know that's only 1 minute. Now, it is the question of how far the principle pacta sunt servanda applies in the situation if one party of the agreement does not comply with the obligations which is party of. It means the question is whether constitutional identity might be perceived as a tool, might be perceived as a license of breaching international agreements. It is the question of practical constitution, as it was the case in Poland 2006-2007, at the very beginning of the process of erosion of basic value of democracy and human rights. And it is the question vividly discussed in Europe, Hungary case, because Hungary became a big European issue. Thank you very much for attention.
Thank you very much. And now I turn to Professor Kumm, who will reflect on Europe and hopefully the rest of constitutions from a truly comparative perspective.
Thank you. I don't know whether I'll fulfill those expectations. But when I first read this question, I thought the obvious answer to it is it depends on which international laws, and it depends on your understanding of democratic constitutionalism. And here is a very straightforward and simple way in which one might say the answer to the question is straightforwardly yes. Supranational institutions and international law does erode constitutional democratic systems. This has to be true if you believe the following. If you believe that the right conception, the most plausible conception of democratic constitutionalism is one in which a national constituent power, a pouvoir constituant, can determine by some kind of qualified majority system what is the content of the Constitution, and then create a space for, within that framework, for majorities to make decisions for the national community. If that is the normative ideal of democratic constitutionalism, then the moment we have an increasing range of constraints internationally, generated by international law more generally, even if it's by treaties, but certainly by supranational institutions, then there's always going to be a loss. At least a loss along the democratic dimensions here, because there are less questions. The scope of democratic decision-making, the scope of constitutional self-government is increasingly restricted. Now, I think this answer, the answer that supranational laws erode democratic constitutionalism, is a false answer. It's a false conception, it's a misguided conception, I think, of constitutional democracy. Constitutional democracy is not appropriately understood if we understand it simply as a pouvoir constituant determining in some way or another through the formal mechanism of a constitution, which probably is more difficult to amend, what the framework for a national majoritarian process should look like. So that's not what I think a plausible and normatively attractive conception of democratic constitutionalism is about. Now, I'm not going to develop in rich form an alternative conception of democratic constitutionalism, but I will point to a number of features that a more plausible conception will have to integrate as they relate to international law. So I will come up with constraints, if you like, that relate to international law that any plausible conception of democratic constitutionalism will internalize in some way or another. So, and in particular, I want to focus on three aspects. So here's the first. If we ask what for the most part is traditional international law, much of international law, not all of it, perhaps not even most of it, but a great deal of it, what is it about? Then the answer is a lot of it can be understood in normative terms to be about creating the preconditions for legitimate self-governance on a state level. So the idea is that the international legal system provides the structure within which it is then permissible for states to find their own way of governing themselves without too much regard to the outside, but only within the structure that international law defines. So if we focus more closely on the kinds of things that even traditional and much of modern international law regulates, it concerns, for example, matters relating to peace and security. So is it a restriction of sovereignty if a country is being told it can't produce nuclear weapons? Yes, of course it is. Is there a problem with regard to democratic governance, with regard to democratic constitutionalism, that a country is told that it can't do so? Well, maybe the answer is not a simple one, but if you make certain assumptions, and certain assumptions also about how that decision was taken by the international community, then the answer might very well be that there is simply nothing of value lost if a country is being ordered by international law not to produce weapons of mass. And that's just one example. So the prohibition of the use of force, all types of restrictions relating to armament and the types of arms you may have, all of those rules are restrictions on state sovereignty and in that sense on constitutional democracy understood in the formal sense that I've previously mentioned. But it would probably not count as anything that would amount to an erosion of constitutional democracy once we understand it in a normatively richer sense. So to a significant extent, much of international law, I think, can be understood as dealing with the danger of and potential of negative externalities of state actions, dangers relating to one country evading another or threatening another. Or it doesn't just have to be the use of armed forces. If we think of environmental treaties, it might be about the dangers emerging from industrial plants positioned close to the border, producing externalities across the border. And then international legal norms, treaties, have the function to address fair standards for ensuring that these externalities are taken into account in an appropriate way. That's what international law, a lot of international law does. It addresses the problem of harm caused to outsiders by national practices which might well meet constitutional democratic standards in a formal sense. And to the extent that that international law restricts constitutional democratic self-government along those lines, it is not undermining any plausible conception of democratic constitutionalism. It is just ensuring that the preconditions for legitimate self-government are met. So that was the first point. But of course, international law isn't just about that. International law also increasingly, since the Second World War, addresses questions relating to the internal structure of states themselves. So human rights law in particular is ever more increasingly institutionalized in sometimes quite intrusive forms, such as, for example, in the European, not the European Union, under the European Convention of Human Rights in particular. So when the Venice Commission hands down its judgment on what it thinks of reforms going on in Hungary relating to judicial independence or the structure of the media, etc., then that is certainly an intervention into the domestic affairs of a country. It's certainly a restriction of sovereignty understood in the formal original sense that I mentioned first. The question is, what justification is there for this type of intervention? Why should there be international standards relating to the internal structure of states rather than just laws dealing with potential externalities and harm caused to outsiders? And the answer here, I think, at least part of the answer, is the following. We have good reasons to endorse international institutions that supervise, interpret, and provide counsel with regard to questions of human rights, democracy, and the rule of law, the whole domestic institutional structure, because the modern grammar of constitutionalism operates with these ideas as foundational ideas. So if we talk about democratic constitutionalism, we don't just talk about formal mechanisms of decision-making. The Constitution as a formal document that requires qualified majority to be changed. Democracy as a formal procedure by which majoritarian decisions are made. We are talking about a way of justifying legitimate authority that makes reference to the idea of rule of law, human rights, and democracy, understanding that these three ideas, highly contested, each of them in and of themselves, relate to one another in a complementary way, even if sometimes also in tension. So this is the kind of the universalist grammar of modern constitutionalism, that it insists on the justification of all public authority in terms of the rule of law, democracy, and human rights. And if a state wants to make that claim, it wants to say, I belong to this universalist family, I am in the tradition, if you like, of the French and American Revolution and the Enlightenment tradition that it is part of, then it has subscribed to a universalist grammar, and it only makes sense that, given the universalist nature of this structure, that there are institutions charged with ensuring that this grammar is not abused and misused, and provides some kind of framework which allows for national claims to be questioned and reflected before the backdrop of an international community that claims to subscribe to these values. So, in principle at least, there is nothing problematic, and it is even desirable for there to be perhaps in some instances sufficiently deferential, but nonetheless engaged institutions supervising human rights, democracy, and rule of law issues. Now there's of course a third area when we think about what type of things are subject to supranational decision making. It's not just peace and security issues. There's the UN, and to some extent connected to it, the laws of war and the ICC. It's not just human rights. We ought to, hopefully we'll find more in the environmental area in the future. Right now we don't have very much there yet in terms of an institutionalized infrastructure. But a third area, of course, is trade and establishing markets, trade, investments, markets. Whether we have the WTO as a quasi-universal institution or regional institutions like NAFTA on the one hand, and of course way beyond just the common market aspect, but nonetheless the common market at its heart, the European Union. Now, with regard to the European Union in particular, the justification for having these types of arrangements is a different one. They are really based on mutual benefit to begin with. They're unlike the human rights treaties or the best normative way of understanding the peace and security arrangements and treaties that deal with externalities and harm to outsiders. When it comes to trade, that's about creating general prosperity, certainly, but states do that in a way that they give something, they have to open their markets in order to gain access to the markets of others. This is true for goods and services, and to some extent in the European Union, at least also for workers, certainly for capital. And in the European Union, we've seen the dynamic that originally some who created the European Union wanted to see, the kind of spillover that leads from negative market integration rules, just a prohibition of barriers, to positive market integration rules, harmonization to ensure that barriers are more effectively removed. And from then, the idea that there's additional gains by having a monetary union. And finally, of course, if you have a monetary union, and that's what we're realizing now, you also need quite a significant degree of fiscal harmonization. And all of a sudden, you end up in a world where supranational institution of an administrative character with some degree of democratic input through the parliament, but nonetheless primarily an administrative run, intergovernmental plus bureaucratic input plus a little bit of input by the European Parliament. So this complicated process, which certainly does not meet, and we should say that clearly, this does not meet standards that we are acquainted with from the domestic context of democratic accountability. We have a process which in the future we can expect to be used to supervise most of European countries' budgets on a regular basis. So we can, if the fiscal treaty will enter into force, and of course the not so secret is even if it doesn't, it wouldn't change anything much because this is already decided in the form of the six-pack, a bunch of rules which effectively address most of the issues, except for some minor ones, that the formal treaty is addressing. So that'll happen anyway, even if there's going to be a problem with the ratification of the fiscal treaty. But nonetheless, we have in this fiscal treaty the establishment of a rule according to which every country is basically committed to a balanced budget. And one thing that is completely predictable at this point is that once this requirement kicks in later on in this decade, it's not going to be met. And then the question is, what happens then? And the core thing that happens then is that the Commission is then authorized to negotiate with each country requirements as to what it is that they have to do to meet the standards, the austerity standards imposed by the treaty. So from that time onwards, we can expect the Commission to play a central role in a domain which has been traditionally the core of democratic self-government as part of parliamentary practice. If parliaments were proud of one thing when they fought for more and more powers against the executive in the 19th century, it was about budgetary autonomy. It was about the authority. The executive could make all kinds of decisions. But when it came to setting the budget, well, that was the parliament's most significant role. And now in the European Union, we're going into a process where exactly that authority is now being moved, is likely to be moved, if my prediction is correct, to an executive body that is difficult to hold accountable, the Commission. Now that is a problem. But what is the solution to that problem? Well, one possible solution, and on this I might disagree, I think, with Dieter Grimm, even though I'm not sure about this, a solution to this is to ensure that in the future, the Commission President and its commissioners will be held democratically accountable in rather conventional, unoriginal ways. We could imagine that before the parliamentary elections, each of the main party coalitions will present their own candidate and say, look, if we do well, if we win, then this is the candidate and the only candidate that we will tolerate as being appointed by the member states, will tolerate as being recommended by the member states as the future president. Right as it is, even within the existing treaty structure, it's the parliament that appoints the president, but they have to appoint whoever it is that the executive branch is actually would recommend. So it's an open question right now what that means in practice. In practice, it has meant so far that the parliament just accepts whoever is the agreed candidate put forward, with qualifications and with questions and answers and etc. But ultimately, the parliament does the outcome of the European elections have not determined who the president of the Commission will be. That was left to the national executives to work out for themselves. They were the ones in the driving seat in this process. And we can expect that, or there's a possibility for that to change, I think, if in the next European elections the candidates of each party puts forward a candidate and starts campaigning with a program and policies that are differentiated from the programs and policies of the other candidate, and they have a genuine campaign. And then let's see what the outcome of that campaign is, and let's see how the negotiations go when it comes to the appointment of the president. The current president of the European Parliament, Martin Schulz, has already indicated that this is exactly what he hopes to be doing in the next European elections, and has thought it was a big mistake not to have done that already in the last elections after it became clear that Barroso would be the Conservatives' candidate. It would have been, he said, it should have been the case that the socialists, the liberals, would have also come together and said, well, here's an alternative candidate that we put forward, and we're going to campaign using this candidate and the team of people around him. And if we do something like that, then it might very well be possible even within the existing structure of the European Union. This doesn't even require further treaty reform or a new constitution or anything like that, to restore the kind of accountability that isn't all that different, I argue, from the type of accountability that we are familiar with from the domestic context. So that's how I would think about addressing the issues in the European Union, which are quite distinct in my view. That's important to keep in mind from the type of issues that we see in other supranational institutions. If we talked about what the UN is doing, or what the ICC is doing, or what human rights regimes are doing, they have an independent justification. And it's that justification we always have to keep in mind when we ask how it relates to constitutional democracy.
Thank you. Thank you very much. And actually, I'm hearing two stories from the panel. One is on how we are using long-established constitutional structures, and the other is on the spillover theme, whether from a spillover we are moving to some sort of renegotiation of hidden or unspoken premises. I wouldn't go as far as challenging the very basics of universalisms or beliefs about universalism, but it was very interesting. So I'm wondering if you have immediate reactions to each other at this point, obviously.
Maybe to your points in a limited way, but I think it will be easy to bring them in. But what Miroslaw Wyrzykowski introduced was an interesting distinction between positive and negative erosion of national democracy. There are erosions that apparently that improve national democracy, and there are erosions that do not improve national democracy. I find that quite interesting, and I certainly agree with that to the extent that the answer to the question, is there erosion or not erosion, depends on whether the national democracy we are talking about is a good, working, well-functioning democracy or not. If it is a very badly functioning democracy, then of course the erosion of the bad sides of that democracy are positive. And if it is a well-functioning democracy, then we might speak of this in different ways. So this, I think, is a point that certainly has to be taken into account. Which national democracy are we talking about? And there will certainly be a difference if you go to some African or Asian states, or if you go to the majority of the member states of the European Union. In general, I think, if we talk about the latter, and this was what we more or less did, talking about the European Union, in general, I think I would uphold the idea that the preconditions for a lively, not only formally but materially, substantively understood democracy are better within this, on the state level than on the international level. But this doesn't count for the whole world, and it doesn't count for every international organization in the same way. But in general, with a broad generalization, I think the preconditions are better, and this should influence, if we believe that, this should influence our judgments on erosion or not erosion. It's very difficult, of course. What came to my mind when you spoke was the International Monetary Fund. You mentioned it in your introductory remarks. Very often the International Monetary Fund makes its funding of states dependent on internal reforms. And mostly we would welcome these reforms. But what effect does it have on the national democracy? Does it have the effect that the institutions will, after the intervention of the International Monetary Fund, be better than they were before? Or does it have the effect that the population gets the impression that its own democracy doesn't really matter? The important things are decided and imposed from the outside. What is more important, what is less important? So, an interesting idea, but it forces us, and this is certainly good, to differentiate more than we could do in 12 minutes or 15 minutes. And Mattias Kumm, in a way, pursued this subject by saying that there is a possibility, even a good chance, that international law improves national democracy and does not deteriorate it. I certainly agree with you that this first type of constitutionalism with which you started is no longer a type that we can talk about under conditions of internationalization and globalization. And I regard that as a progress, because not everything that may be democratically decided within a state can be justified by relying on one's own democracy or justified by relying on one's own sovereignty. Genocide within the state, putting parts of the population into a slavery status, can no longer be justified by it was a democratic decision or by saying this is our sovereignty that allows us it. Insofar, clearly an improvement. When it comes to questions other than these, certain things that we would abhor today, tolerate under no circumstances, where it is certainly good. When it comes to other questions, is the internal substance, is what I call the societal substructure, the societal preconditions of democracy, are they improved? Then I'm less optimistic. I'm more optimistic when it comes to saying no to certain actions that formerly were justified by democracy or sovereignty. When it comes to the substantiality of democracy, I'm less optimistic. But we don't disagree with you. You mentioned that perhaps with regard to your last point, the consequences of the current financial crisis. I think that it is the outcome of the financial crisis will be a gain on the executive side of the European Union, and as a consequence of this, it is absolutely necessary to strengthen European democracy And one way of strengthening European democracy is to make European elections matter more than they matter now. And this is what you suggested. But I think it has a link to what I said toward the end of my remarks. You will not be very successful in making the elections matter more as long as this situation exists that the treaties, that's to say the European Constitution, so to say, is full of ordinary law. It should be accompanied. If the treaties are made a constitution, they should look more constitution-like. That's to say, they should free themselves from all this stuff that in the member states is on the level of ordinary law, that's to say, open to political decision. So this, I think, is a complementary side to the suggestion you made.
Only one comment concerning Dieter Grimm's statement on the role of veto as an instrument of getting better results from the perspective of national interests and sovereignty. In Poland, we have had democracy in 15th, 16th century, where the concept unanimously, decision should be taken by the parliament unanimously. And we have had a liberum veto, so-called liberum veto instrument, as a potential instrument to use in case. More than 200 years, we didn't use it. Once it happened, one member of the parliament was bribed. Corruption is not the idea of this century. And the parliament stopped its work. Once, second time, third time, and Poland collapsed. It is not prediction for the European Union. It is only an experience of the history that indeed, as Polish parliament then, European Union today is constructed on the concept of compromise and consent, not conflicts. It's everyday issue. But I'm very much afraid of the idea of veto, because the risk of abuse this idea might be much bigger than the profits of potential use of it. But we have this institution now in the mechanism of controlling of behavior of member states of the European Union. But if we see NATO and France in 60s, empty chair, and if we see now the games and the place in the European Union warning yellow card, if do not agree, I will veto this decision. It is a sign that there is more tension and conflicts than the basic elements of agreement and readiness to get compromise. Thank you.
I wanted to make 2 points. One of them was concerning your presentation. I thought it was very useful and to say in this context of this subject matter, to focus on the role that international law has played in the context of the constitution of new states and ensuring that they meet certain basic requirements. And in that context, it also shouldn't be forgotten that however we, perhaps as political scientists, might think about the causal mechanisms here, but there is a widespread belief that I don't think is false, that the European Union has played a significant role as a discipliner to ensure that member states did not slide back, or have not slided back for a long time, into authoritarian type of regimes. Now, I know that what the role of the European Union has been in that regard and how the causal mechanisms operate. This is difficult terrain. But at least it's an idea that I want to put on the table that is thought to be quite plausible by some. So that there is this connection, that there is a strong connection. Now, forget about the European Union context, that was just one example. But there is certainly, historically, a strong connection between the type of domestic structures states have and the kind of international legal system that they are part of. And it is only in an international legal system that is relatively strongly institutionalized and that has a commitment, theoretically and also worked out in through some institutional mechanisms, to human rights, etc., that we are actually likely to see in a stable, persistent way the spread of liberal democracies. It is not a surprise that during the Cold War, when many of these institutions were not fully developed, or even if developed, not operable, that whenever there were movements from authoritarianism to more democracy, it was very likely that that shift was being vetoed through power politics and intervention by one of the major superpowers. And that's the story, whether it's in Budapest, in Hungary in 1956, or Prague in 1968, or for that matter, whether it's Iran in 1956 and the election of Mossadegh and the restoration of the Shah. And you could go on with these examples. So having an international system that is characterized by great power conflict as its defining feature, rather than a relatively strong institutionalization of the rule of law committed to certain procedural and substantive values, it makes a difference for what type of domestic constitutional structures are likely to develop and flourish. So in that sense, exploring that connection in greater depth, I think, is a very worthwhile enterprise, suggesting that a certain type of strong supranational institutionalization, including a commitment to human rights, etc., actually supports and strengthens worldwide the institutionalization of constitutional democracy on a national level. Now, the second point concerned the preconditions for democracy. This is a point I know you've had many debates with many people about. But I don't know what the answer is that you've given to one. So it's one simple, relatively simple observation. I'm sure you have one, but I haven't heard it yet, so I'll ask the question. Anyway, why wouldn't it be the case, or given that historically it's been the case, that at least in many contexts, not everywhere, but in many contexts, the institutionalization of a certain process has then triggered the evolution of a social process that created the kind of infrastructure that democracy needs to work well. So why wouldn't it be the case that perhaps through an audacious commitment to an institutionalization of genuine electoral accountability and moving away from the consensus model that has traditionally played a central role in European integration, why isn't there at least a good chance that what we will see as a result is the development of exactly whatever you might think the intermediary infrastructure actually is? So isn't this just a question of sequencing? So why would it need to be the case that first there has to be the infrastructure and then we can build the institutions? Why isn't it the case that it might also work, as it historically has in many places? And even in France in the 18th century, many French could not speak French, and the reach of the institutions didn't go very deep, yet establishing a certain type of constitution and a certain type of political structure over time tends to foster the kind of evolution of the type of infrastructure that participation, media, political parties, etc., that you need for a well-working democracy. So why shouldn't the sequencing work that way around?
Sure.
Only briefly, in order not to block the audience, I don't deny it as a possibility. I don't deny it as a possibility, and to a certain extent over the years, even in this short span when I first expressed my ideas, and now something has happened. Yeah, we are no longer in 1995, when I think for the first time, or 1994, I talked about that. So I think it is. I don't deny the possibility, but I think it is much more difficult. It's easier to go ahead with the institutionalization process than to have the societal processes follow. And my main concern is, of course, that Europe is different from the United States. Persons from many countries came to the United States and integrated, but they left their home. They left their home, they knew they start anew. They didn't remain where they were. And they acquired over time the proficiency in the English language. It's a little bit declining right now. In Europe, they stay where they are. That's to say, they continue with their cultural habits and traditions. And the most important thing, in order to be sure, the most important thing, what I don't see happening is that we get truly European media. That would require that we talk about the same thing in more or less one language, or that everybody understands everyone else's languages. There is no economic basis for European-wide media. And I think this is the most important impediment for a truly European discourse. What we still have is 27 national discourses on European matters. And when you travel from one country to the other in the same period of time, you get the impression that every country talks about a different thing when they talk about Europe. So the velocity, so to say, of the two processes, institutional change and societal change, are very different.
I mean, maybe a quick point, and then I let the question to the audience to ask questions, because the whole point about compromise and consent and unanimity came up. And very often these procedures are pictured as barriers to moving forward, that you cannot do something because there is unanimity requirement. But what you see more and more with the union now is that actually the consent or compromise requirements protect the status quo. And especially with the Hungarian saga, you are back to the old pre-accession conditionality and post-accession performance debate. And in order to accommodate quite a bit in the financial crisis, but also to discipline the unruly member states, you are actually asking questions about that status quo, which was taken for granted. And it was interesting to see how the whole institution building and sequencing issue feeds into that aspect of the discussion. So there is an eager audience there, I'm pretty sure. So I suggest we collect a few questions and then you get to pick and choose. If you put your... Dora, please. Dora Tabola from Political Science.
Thank you. Thank you for a very interesting panel. I enjoyed it a lot. I wonder, and this is especially concerning the European part of the story, I wonder whether we get to the problem if we don't talk about what is exactly being constitutionalized. And I mean, both Professor Grimm and Kumm started to talk about it, but I think we know more than that. It's not only about trade, and it's not only about capital movement, but it's basically about an economic order now after the financial crisis, which is the attempt of constitutionalizing an economic order that imposes permanent austerity. And then you get, of course, into trouble because that's not popular, right? So whatever is the problem with democracy in Europe has a lot to do with what is being constitutionalized. And I think if we don't take this into account, these solutions, like having now the European Parliament competing over who should be the commissioner or the president of the commission, will not really solve the issue, because the person can only have different ways of institutionalizing austerity, but has not any longer the means to debate whether we want austerity or not. And this is being taken out by constitutionalizing this neoliberal austere order. And I wonder what your thoughts are on this, and you know how we get out of that trouble which we are having in Europe currently.
Professor Dimitrievich.
Thank you very much. One of the established features of political regime is that it is actually programmed for coercion. and we expect democracies to ease the pain. And the strategy is very simple. We say, well, it is really about coercion, but I agree that coercion be applied against me. Well, this is not necessarily true. In democracy, I agree that coercion be applied against other people. So if we are members of the same political community, I agree that coercion be applied against Doro. I don't agree that coercion be applied against me in the first place. This is the first addressee of the coercion. Now, the question then is, what is good about democracy? If self-government means that I agree that coercion be applied against her, and I believe that democracy cannot be legitimized, and I come here close to my liberal reading of what Professor Kumm said, democracy cannot be legitimized or justified by recourse to democratic principles, to principle of self-government. Democracy needs something else. Democracy needs those universalist values that Professor Kumm was talking about. Then, if democracy needs those universalist values to justify its existence, and it needs them because there is nothing in democracy, let me use the words of Frank Michelman, there is nothing in democracy that would point towards rightness of democratic decisions. Nothing in democracy points towards rightness of decisions. Then, what is the way out? The way out is to remember the sad history of this small continent. The European Union started with universalist values in its whatever Rome-Paris treaties and Schuman Declaration. And it was for good reason. It was because European democracies failed miserably. After the miserable experience of the Second World War, and after equally miserable experiences of the country I originally come from, what was Yugoslavia, I don't have any reason to believe in the strength of national democracies to handle their own affairs. Universalist values, as embodied originally in the idea of the European Union, are the only reasonable protection of democracy at this continent. The only problem is that somehow, somewhere down the road, the EU lost the clear sight of its universalist values. And then the whole story started to become too complicated, as, for instance, the Lisbon decision of the German Constitutional Court has demonstrated, where, for instance, I believe one problem is that democracy gets too easily equal with sovereignty. These are two different things, right? Thank you.
And let's take one more question. And oh, sorry, Orsi Shalet.
I have two questions. Is it turned in? Yeah, okay. So a little bit related to what Professor Dimitrievich probably pointed to. So what do you, Professor Grimm, think about this Staatsaufgabenlehre? What was that exactly in this Lisbon decision of the German Constitutional Court? So this is what you meant by the quantitative aspect? Yeah, so that's why, okay, because and is there no tension between that and the fiscal union actually pursued by the German government? Because fiscal is part of that list of, as much as I understood. And the other thing to all of you, but maybe it's too out of the context of the specific, or too specific for the topic, but would you maybe have some comment on this, what came to be known as the Heidelberg proposal for the for bringing cases before the European Court of Justice in cases there is a massive degradation of human rights situation in some of the member states. So this reverse Solange debate, maybe. Mm-hmm. Thank you.
Okay, so who wants to go first?
I think the question, what is being constitutionalized in the European Union, is an important question, because not everything. There is more constitutionalized than it would be on the national level, and at the same time there is less constitutionalized that we have and would have on the national level. I think the answer you gave yourself an economic order is constitutionalized is certainly true for the beginning of the European Union, for the early years. Meanwhile, it is more than only an economic order. But in my opinion, still the economic bias is very strong in the European Union. And the most significant feature of this for me is that the 4 fundamental economic freedoms were constitutionalized. That's to say, they were turned from principles for political action into subjective rights of citizens against their own state. And it still seems to be the case, if I regard the jurisprudence of the European Court of Justice, that there is a tendency that the economic freedoms prevail over personal rights, communicative rights, cultural rights, etc. This is an important, I think this is an important, if it is true, it is an important result. And I put a certain hope in the fact that we now have a full-fledged Charter of Fundamental Rights in the European Union, so that when it comes to balance economic freedoms against other freedoms, the European Court of Justice could be in a position to reach more balanced results than it does now. Whether it uses the opportunity that the Charter offers, I'm not totally sure. But certainly the possibility exists. This would more or less be my answer to your question. Your remark, I think, goes to Mattias Kumm. I'm not sure whether I understood everything what you said, but the first point was were the remarks in the passages in the German court's decision on the Lisbon Treaty, where the court first reiterated what it had said in the Maastricht Treaty. There is an uncertain limit where quantity changes to quality. So if so many powers should be transferred that no longer any political substance of some weight remains with the German parliament, then we have to say no to the European Union. But now this was in the Maastricht Treaty, but the Lisbon Treaty adds, what it adds among others is a list, and I think you may have alluded to that, is a list of legislative matters. And what does this list mean? The court says there are some subject matters that are closer to national interests, to national traditions, to national culture than others. And then it mentions a number of items, family law, criminal law, etc. What is the impact? I could not find any sentence in the judgment where the court says, and these are matters on which the European Union is barred from legislating. I didn't find anything like that. The court at another place in the decision even said, there is no special matter which is by itself barred from being handed over to the European Union. And I didn't find any sanction. What happens if a power in family law or in criminal law is transferred to the European level? I didn't find any. So I think, in my view, it's a wonderful example for an obiter dictum, of which this judgment is full anyway, where the court says, when it comes to these matters, German legislature, when you hand powers over, European institutions, when you use these subject matters, pay attention and look to how deeply you go into national matters, but not a barrier. This is my understanding. The second was the reversed Solange. This is the suggestion that von Bogdandi made in a blog. I read it, as a matter of fact. I'm not yet accustomed, I'm too old to get all my information from blogs. I should change that because very often it's interesting, and this belonged to the interesting things. I have no final judgment of it, but I can say I found it interesting. And the more interesting, the more democracy regredes in some member states, or there is a danger that democracy regredes in some member states, the more interesting may be this suggestion.
Thank you. I think that's because this one.
Yeah, so first, and to take in reverse order, I think even though it was just in an obiter dictum, but the whole idea of an essential core of sovereignty, which somehow we need to protect absolutely, I think that has a certain symbolic, expressive significance. But operationally, if there is a plausible reason that justifies making a decision on a European level, then I cannot imagine any kind of situation where the court would say, yes, we recognize there's actually a plausible reason to have this decision Europeanized, given a certain kind of context of interdependence and collective action problems, what have you. But this is a core of sovereignty, so we can't do it. So I just don't think that is how the court would approach it. It's not clear how it would approach it in any other way. So I think basically, just like in the area of the dogmatics of the Grundrechte, there's also the Wesensgehaltstheory, the idea that there is a core of rights that can't be infringed. And I think dominant scholarship gets it right and reflects also, I think, dominant practice, which says basically what this means is we apply the proportionality principle correctly. So I don't think there's much significance to the rhetorical invocations of essential cause, whether it's to sovereignty or whether it's to rights. Now, what is being constitutionalized? I think there is something quite deep and significant that you point to. And there is no other constitution that I'm aware of that actually constitutionalizes an independent central bank committed to a monetarist policies. And now constitutionalizes basically a balanced budget. Now, there are a couple of examples of that, but there are quite few, and they're quite recent. So that's, I think, not just the negative rights are prioritized over other values, but these types of institutional features of monetary and fiscal policy. That is something that is a remarkable feature, to put it neutrally, of the European constitutional process. And that is, of course, something that can't easily be changed through enhancing the electoral accountability of the Commission. But it's imaginable that these rules, say the balanced budget rules, their practical significance lies in the sanctions that they authorize. And when it comes to the exact nature of the sanctions, there's a lot of leeway. And the Commission is the institution that has to ultimately exercise the discretion and work out and negotiate with each of the states that's violating the rules, what exactly is required of them. So we can imagine how a lot of these problems might be mitigated on application. So that is not a solution generally to the problem, but it's at least points to a direction in which the tensions could be mitigated. By the way, just to, when the idea when the European Central Bank was erected and when the Treaty of Maastricht was negotiated, which first established the European Central Bank and its independence, the idea was that Germany is the model. But of course, in Germany, the independence of the central bank was in part laid down in its statute, ordinary statute, and its monetarist focus was part of political culture, economics culture. There was no legal commitment to it. So you basically have a practice, a legal and cultural practice, which is then given legal form and made unchangeable or very, very difficult to change in constitutional. So that is a remarkable feature of the European Constitution to keep in mind. Now, with regard to the remarks on democracy, I think you are right about one thing. We should never forget, and this isn't about devaluing democracy, I think, but we should never forget that the reason we are right to value democracy is connected to the fact that we often reasonably disagree about things. But if a majority decides something for which there is no plausible justification, and plausible justification being one that takes that in its justification clarifies how it takes each individual seriously as free and equal. If there is no such plausible justification, then it doesn't matter what the procedure was and how many were in the majority that decided that law. It would still be deeply problematic. So there's always, I think any plausible conception of democracy is internally connected to substantive standards, the specifics of which in concrete cases are likely to be subject to reasonable disagreement, which is why we don't want to have some institution made up of expert philosophy professors or judges, etc., making general determinations. We want that to be an open public process. Also, not just because we think that way the results get better and more often closer to the truth, but also because the fact that somebody believes something to be right, as long as it's plausible, has independent significance. So I think that doesn't undercut anything that you said. It does connect the idea of democracy and insists that the idea of democracy is connected to universal standards of rightness. But it's still, that doesn't mean that we shouldn't value democracy.
3 short comments. Firstly, constitutionalization of economic order. In Poland, we have provision in the constitution that the annual deficit cannot transpass 60% of gross product, national product. And it is guaranteed based on very, very extremely bad experiences of the past, that the government will behave in the proper way from the point of view of responsibility. And if it would be a breach of this rule, the Prime Minister and the Minister of Finance will be responsible in the penal procedure before the special court because of violation of the Constitution. It is not a tale of the future, but still it is an element of the Constitution in Poland. So, for us, fiscal pact, and I don't know whether we will be a member or not at the end of the day, is not an evil because we are experiencing these limits for the last 15 years. Secondly, Professor Dimitrievich, erosion of the human rights and the standards of human rights. I totally agree with you. From the perspective of a person stepping up from Poland. And all depends on the standard. We are take it as a starting point. And for us, for me, for example, discussed in this room 2 years ago, the KISS case before the European Court of European Strasbourg Court, and impact on the Polish constitutional system is an example how international law may improve domestic legal system, put on a higher standard. And last point. Von Bogdan, the proposal. I would be extremely cautious. Why? Because, as I understand, it would be mass violation of human rights as a precondition in the member state of the European Union. What it means that indeed something dramatical happened. Without reaction at the very beginning by the authorities of the European Union. If it is mass violation of human rights, if I understand correctly. Systematic.
Something what would be,
But okay, systematic.
Reverse Zolanges, so as much as
Yeah.
it would be too much.
But
for
okay.
if the EU doesn't do something of it.
The second question is, what a standard of human rights should be applied? Who should define the standards of human rights? ECJ, not having instrument yet, not being a part of the taking of the European Convention, taking as pepinnerie of the standards, common European tradition, constitutional traditions, and that I understand it is ultima ratio as an element of potential doing, but a risk, political risk for the court, in my opinion, would be too big to allow to the court to give the court this type of competences. First comment is I'm very skeptical.
Well, thank you very much. János Kish in the middle.
I have two comments on 2 points Mattias Kumm made. I agree with both points, but I want to suggest qualifications on both of them. You were saying, Mattias, that value of democracy is intricately linked with the problem of reasonable disagreement, and one reason why we need democracy is that we need a process in which the considerations of all are taken seriously, and in this way everybody is treated by the process as equal concern and respect, and I agree with this. But let's translate this to the problem raised by Doro. How do constitutions respond, if they do respond correctly to this problem of reasonable disagreement? They respond to it by using a wording which is abstract enough to allow interpretation, okay? So that those who disagree with the now dominant position have a room for a political fight to change the interpretation of the Constitution in the way they prefer it to be understood. Treating citizens as equals, for example, equal dignity, all these are very abstract principles. Now, the provision on balanced budget enshrines a controversial position into a rigid constitutional rule. And I'm not sure that is the right way to go. Whether or not the position itself is correct, that's a different matter. The issue is that, as we know very well, even in the midst of this particular economic crisis, it is hotly debated whether states should go this way or that way. Perhaps it's not the case for all states to go the same way. So that is one point. The other point is related to your claim that if one goes ahead with institutionalization, provided, of course, that institutionalization directs towards a plausible evolutionary tendency, social process will follow. And you, and I fully agree. And you referred to the example of 18th century France, where perhaps not even the majority of French spoke French of Ile-de-France, right? That was not the case. And then within a couple of decades, the French nation was born. Now that's correct, but as we know, a tremendous amount of coercion and violence was used in order to make this possible. And fortunately, that option is not available anymore. Okay. Which means that when we think about a process of European integration, we have to consider that the battery of means to promote the process at the social level is more restricted than the one which was available at the time of Robespierre and company. Now, well, it was continued all over the 19th century in France, as we know very well. It was not just Robespierre. What I think we now see is a kind of identity backlash to the shock in many countries of Europe, probably in most now, given the economic crisis, to the shock of integration. German taxpayers don't want to fund a stabilization. In Greece, Greek taxpayers don't want austerity policies imposed by Angela Merkel on them. Excuse me? Which I understand. No. That's I don't want to use evaluative terms here. I'm just speaking about the present situation. So we are undergoing a period of identity backlash to integration, and I think that one aspect of the present Hungarian constitutional crisis is precisely this kind of backlash, not just to European integration, but to transition from communist to democracy, from command economy to market economy, from Soviet domination to European integration, and so on and so forth. All this is in many ways wonderful, but it also elicits a backlash, and this is perhaps the extreme edge of a continuum where each country has its own problems.
Thank you. Ron McCree in the back.
Thank you. Just a slight to pick up on one of the points there, and the one that Professor Kumm mentioned was, we talk about entrenching certain constitutional norms, and in relation to the title of the talk, in a way for EU law, it's true that every single piece of European legislation is effectively a constitutional norm, because the threshold for passing a new one, for amending it, is so high that it's actually easier to amend many national constitutions than to amend many normal legislative acts of the European Union. And that does introduce a really dangerous rigidity with real dangers of capture of the legislature by certain interests. Common agricultural policy cannot be reformed. Do you see a real danger going forward in a world that is so full of changes? The EU is really stuck with legislative solutions in every area that it comes with, because it's just impossible to change. You need 65%, and that's a very dangerously rigid system in a changing world.
Okay, I would like to exercise the totally arbitrary powers of the sovereign and ask Mattias to respond in about 5 minutes, and after that we close the session here and move out for food and drinks. So that's the grand plan, if everyone agrees.
Don't you want each of them?
They all went to you, I'm afraid. So.
Well, okay, doing it backwards again. The rigidity issue is a problem, but we shouldn't overestimate its significance. It is still the case that most legislation, or most proposals that come from it's not that difficult at the moment. Now, the interesting question is what would happen if a politicization along the lines that I advocate changes that. But as things currently stand, the 65%, or the complicated formula that is currently used to calculate what the necessary qualified majority is often enough not a significant barrier. So I think with regard to the reform of old laws that some argue ought to be changed, this is the type of thing which in the past has not yet proven to be too heavy a burden to actually effectuate change. Now the question is how politicization will affect that practice. And there might be a problem there because we might get more resistance, and with more resistance it might be also more difficult to get anything done, perhaps. So the problem might not just be one of being locked in with decisions of the past. The problem might then also be that it'll be very difficult to get the necessary qualified majority votes to get anything done in the future. So there is an issue there, and I don't have a clear-cut answer as to how it should be addressed. Now, with regard to Janusz Kisz, and if you ask how on a national level do institutions deal with, do courts interpreting the Constitution deal with the fact that democracy is both limited but nonetheless is connected to universal standards, and so there's a requirement that there's a requirement that any decision reached by a democratic legislature has to be justifiable in a certain way. And that's the first hugely important point. I think in constitutional law, modern constitutional law, the way that rights are understood, the way that rights doctrine is structured, it presupposes that if somebody is affected by an act of public authorities, that requires that the act, that individual, that there has to be a justification that the government can put forward for that act that meets certain requirements. Now, what is interesting about more specifically now, about what that requirement is, abstractly you're quite right, Janusz, to say it has to be count as a plausible interpretation of the Constitution. But in practice, very often, most judges in most places in the European Union and also in the world use a proportionality test of some kind. And the proportionality test is a wonderful test in which allows you to not to ask what the right answer to the policy question was that the legislature originally faced. It's not about the right answer in a political sense. What the proportionality test provides you with is a structure that allows you to assess whether there are plausible reasons that justify acts of public authority. Just plausible ones. So many courts emphasize again and again that they're not asking and they're not assessing whether the legislature found the right, best, most efficient, ideal answer to the political program. That's not their job. What they ask is whether or not the decision was justifiable. How closely they look, that will depend. There are various standards of deference that the courts might use. But the point is, it's not rightness. It's a certain kind of plausibility. So the fact of reasonable disagreement comes in there when the court assesses the justification of an act of public authority. I think with regard to France and Robespierre as the instrument by which which French identity was forged, yes, violence has not just in France, but often in many other contexts too, helped to create a collective identity. That's the case not also in the United States. The Civil War was a moment which provided a huge push also for the development of a certain kind of democratic infrastructure, you might say, of ordinary politics in the United States. So the connection between violence, identity, and democratization and the creation of the infrastructure for effective democracy might be uncomfortably close. Uncomfortable in particular for those who are hopeful for the evolution of such a thing in the European Union. But at the same time, I think besides violence, I think energetic politics in which lots of othering also takes place, not the other that you kill, but the other who is your political opponent, who you disagree with. That too creates identity, and ultimately tends to create identity that holds together those who oppose each other in political terms. So I think genuine politicization even though perhaps not quite as effective as violence, is also a way through which identities are forged and can be maintained. And that would be the path I would hope for in the context of the European Union.
Thank you. I would like to thank the panel for this wonderful dialogue and invite all of you for drinks outside.